chat box, which will be taken up by Professor Shapiro depending upon the time. Also note that attendees will not be receiving an e-certificate for this lecture. To begin with the lecture, I request our Honorable Vice Chancellor, Professor Surya Prakash, to give the introductory remarks.
Okay.
So,
good evening to all. And it's a privilege for me to invite Professor Scott Shapiro to this lecture and taking his time to address our students. And the topic is such, it is about jurisprudence. Jurisprudence is an evergreen subject, and it is an international subject right from Thomas Aquinas to John Rawls. So many thinkers, so many others. It's really a fascinating area, and definitely today that Professor Scott will enlighten us more. We are discussing, we are studying, but jurisprudence for everyone, it will be, everyone will give their own dimension. Everyone will understand. Even the same person, when he reads more and more, the understanding of jurisprudence will differ. When we read the jurisprudence, when we were students, we conveyed something, and when we are lecturers, after 10 years, it is something, and when we, after 25 years, 30 years, again when we read, it constantly expands the vistas of the legal knowledge. And what is the point of view of Scott, how they deal with the jurisprudence? Definitely, this will be an enriching lecture, and from the bottom of my heart, I welcome Scott, and also we are very thankful for sparing his time. And to all my students, please listen carefully. And if you have any doubts, clarification, keep it with you. And at the end, there will be a clarification session. And with these few words, once again, I welcome Professor Scott to this online lecture. Thank you. Thank you, Manasi.
thank you, sir. I request Dr. Dayanand Murthy, the Director of Academic Affairs and Research, to give the contextual remarks for the online lecture.
Thank you, Manasvi. I thank Honorable Vice Chancellor Surya Prakash sir for the kind support and the guidance to organize this event of hosting Professor Scott. Yeah, so welcome in for this lecture. I believe that jurisprudence has developed through theories. Thinkers have come in and examined or investigated how law has developed, starting from maybe not only Blackstone, we go back to Blackstone, but going back to Egyptian world, we know that 3000 BC, the law has been evolving. And till today, we have been evolving what law is all about. And the topic title goes to say, what is the law and why should we care? I think that's a wonderful caption, as Sir has already written an article on that particular title. I believe he will justify why he put it in his bracket. Why should we care? And when we look into, I just want to highlight upon how jurisprudence has developed to an extent in India, very briefly. Now, the statutes have come across, the Indian law has come across with statutes where the law has evolved, taking from protection of women, like sexual harassment at workplace, or maybe sati prohibition law. So there are many other statutes which has come through the constitutional protection being given to women here. When it comes to children, we have statutes which have come up very recently, protecting every right of a child being protected here. Similarly, the workmen protection or protection of prisoners. So the law is evolving in this particular case as to personal rights are concerned. Similarly, as the commercial rights are concerned, we have developed a law with reference to Consumer Protection Act very recently. Last week, we have got a new consumer protection law which has come into picture, protecting the consumers as a whole. We have security regulations through SEBI and then anti-competitive regulation through competition law. So we have a lot of laws which have come in, which are virtually called as one of the best in the world today in India. I think that's what the law has been evolving in India as such as to the statute is concerned. And similarly, Supreme Court also has come out with various kinds of development of law, maybe starting from 70s. I think most of the development happened with reference to protection of constitutional rights is concerned, started from 70s, where Justice Bhagavati, Justice Krishna Iyer, whom today the other courts, other country jurisdiction are referring to those rights which have been developed in India. So this is going through, and till today, we have a lot of things which have come in. For example, it may be protection of Muslim women by looking into triple talaq is invalid. We have Nirbhaya Act coming in because of the judicial activism which has come in, where criminal amendment law was brought into picture. And similarly, consumer protection being brought in, domestic violence law has been developed. So these are the things which we look into in the analytical aspects of jurisprudence, basically. Now we have a lot of theories coming in jurisprudence where judge-made law is also accepted as jurisprudence. I think Sir will look into all these aspects and internationally see how jurisprudence has been working on that particular aspect. So I just wanted to highlight and what India is doing it. Probably Professor Scott will cover up as to the whole world is concerned as to how jurisprudence is developing. And that's the caption. What is the law? And who cares for it? Because we all know that certain laws are existing where a common man may not be knowing that whether it exists or not. I have read a case where the magistrate decided a case where the law was already repealed. They decided a case on a law which was already repealed. And that's when a judge does it, we can't expect a common man to know what the law is. And I think Professor Scott will also highlight on how exactly to reach the people what law is one of the highlight of this particular discussion. Thank you once again, sir, Professor Scott, to join with us. And we are very happy and we take pride in hosting you from this university, the DSNLU. Thank you so much, sir. Thank you, Kiran and Manasvi.
Thank you, sir. I would like Kathy to take over for introducing our guest speaker. Kathy?
Thank you so much, Manasvi. Good evening, everyone, and very good morning to Professor Shapiro. I'm Kathy Potula, student of Damodaram Sanjivaya National Law University, and today I've been bestowed with the privilege to introduce our guest speaker, Professor Scott J. Shapiro. Professor Scott J. Shapiro earned BA and PhD degrees in philosophy from Columbia University and a JD from Yale Law School. Professor Shapiro has been an academician for the last 24 years. He started his teaching career as an assistant professor of law at Benjamin M. Cardozo School of Law in 1996, and currently is teaching as Charles F. Southmayd Professor of Law and Professor of Philosophy at Yale University. He has also taught as visiting professor for many prestigious European universities. Courses taught by Professor Shapiro include jurisprudence, advanced topics in jurisprudence, introduction to transnational law, constitutional law, criminal law and administration, family law, legal theory workshop colloquium, introduction to legal philosophy, the law and technology of cyber conflict, the foundations of legal scholarship. He has also written various books and articles, among which his popular writings are the books The Internationalist and Legality. His popular articles for general audiences are The Internationalist versus the Realists and Neocons in Lawfare, Outlawing War and It Actually Worked in the New York Times, On Syria, a UN vote isn't optional in the New York Times, Making War Illegal changed the world, but it's getting too easy to break the law in The Guardian. His podcast Legality is one of the best things that happened during the lockdown. It is my immense pleasure to welcome our speaker today, Professor Scott J. Shapiro, to give us a lecture on what is law and why should we care. Thank you so much.
Thank you, Kathy. So you can take over now. Thank you.
Okay. Okay. Well, thank you so very much. I will say, the last couple of months have been strange, and all, there obviously been extremely awful aspects to it. And one of the terrible aspects, in addition to, this suffering and death tolls is the way in which the quarantine has separated each other from each other. And it's been one of the surprises about this last couple months is the ability to connect with communities that I would not ordinarily intersect, and in fact, am delighted to speak to. So I really one of the upsides is being able to meet people that I wouldn't have ordinarily met or wouldn't have been as easy to meet. So teaching online is strange. And I've talked to students where it's been Zoom, and so you can see how many students and who the students are. So I was talking in Ecuador, and there would be 600 students, then 800 students, then 500 students. As I'm talking, and I'm thinking, wait, I should switch topic because I'm losing the students. So right now, I don't even know who I'm talking to. So I'm going to do my best, okay, to try to communicate with rational minds on the other end of this connection. Okay, well, my name is Scott Shapiro, and as the wonderful introductions, for which I'm very grateful, have mentioned, is that my main area of teaching and research is legal philosophy. I usually teach jurisprudence every year. And when I do, I usually begin the class on the first day by asking students what the right way to interpret the law is. Now, this is a very simple question and is usually greeted with blank stares. What I'm imagining you're doing right now on the other side of this connection. Nobody has any idea what I'm talking about. They think, what do you mean the right way to interpret the law? I think you're supposed to tell us what the law is. But then I ask the question again. I say, suppose you have a statute in front of you, a legal text, a statute. How should you interpret the statute? Again, absolutely blank stares. You can hear a pin drop. So I try again. Suppose you have a statute in front of you that says no vehicles in the park. Someone wants to know whether they can drive an ambulance through the park to get a heart attack victim to the hospital. Should you interpret the statute to prohibit or permit the ambulance to take the shortcut through the park? Now, again, after some more uncomfortable silence, some brave soul will raise their hand and say, well, it depends. If you interpret the statute strictly, then no. If you read it loosely, then maybe. I say, great. But I didn't ask you how you could read the statute. I asked you, how should you read the statute? What is the law here? Should you read the statute loosely or strictly? Again, just blank stares. Eventually, someone will say, well, it depends on which way it helps your client, to which I'll respond, yeah, but suppose you're the judge and you don't have a client. What is the right way then to read the statute? Now, understandably, students have no idea how to respond, and it isn't their fault, of course. It's our fault. By our, I mean the fault of law professors. We don't generally teach as part of basic legal education, or I should be more careful here. At least in the United States, we don't, as basic legal education, teach students how to think about legal interpretation. There are sometimes interpretation courses, but it's not like a core part of the curriculum. Now, I'm not complaining that we don't indoctrinate our students into thinking that there was one right way to read legal texts. What I'm kind of complaining about is that we don't teach our students how to think about interpretive questions. That is, we don't teach them, what would count as a reason to support one way of reading a text, a legal text, over another. They know that there are many different ways of reading legal texts, but they have no idea about how to think about which way is the legally right way to do so. Now, what I want to suggest is that there's a part of legal education that is conspicuously missing. Again, in many countries, but in the United States especially, that is, there's a sense among lawyers and the legal academy that, jurisprudential questions aren't that serious. I go so far as saying that many law professors are not only bored by the subject, but they think it's a colossal waste of time and can't imagine why anyone would do it. And I mean, I find it amazing that I got a job because there really isn't a great demand for it in the United States. Now, this is in contrast to the United Kingdom and many countries on the continent, and my understanding is in India too, where jurisprudence is a required course. It is not a required course in the United States. And some of the very, very top law schools don't even have a course in it. So it's actually a strange thing. I have found that even when some curricula have it as jurisprudence as a required course, it tends to be, treated kind of like tax. They teach you what this person said, they teach you this, and you're supposed to memorize the kind of the standard answers that you get from a commercial book, and it's not the kind of deep engagement with legal theory that when we talk about jurisprudence, we kind of hope we're bringing to our students. So what I would like to do in the time that I have is, first of all, to try to argue that, try to show you at least that jurisprudence is pretty interesting and it's actually kind of fun. Actually, I think it's a lot of fun. But also, and here's the key thing, it also has enormous implications for questions that lawyers and law professors and anyone who cares about the law, frankly, should care about. What I would like to argue now that many of the most pressing puzzles that lawyers confront, including who has legal authority and how should we interpret constitutions and statutes and judicial opinions, the role of custom, will remain elusive until certain jurisprudential questions about the nature of law are resolved. In short, what I would like to show in the, I would say 25, 30 more minutes that I have, is to show that we can't know what the law is many times until we know what law is. We can't answer many of the legal questions we want to answer unless we have a better grip on the philosophical questions about the nature of law and what law is. So what I'm going to make a claim, what I'm going to argue is the reason why you should care about what is law is because the answer to the question, what is law, is connected to the question, what is the law? And insofar as you care about knowing what the law is, you should care about what philosophy and jurisprudence has to say about what law is. And what I would like to do is talk to you about what that question means. Unfortunately, law professors and philosophers, we've not done a terribly good job explaining why jurisprudence matters. And we, by saying like we're trying to answer the question, what is law? I mean, that just sounds like a crazy philosopher's question. Like, what do you mean, what is law? We know what law is. Try robbing a bank. You'll find out what law is. But what I would like to do is I'd like to kind of explain as well as I can within the time period what that question, what the philosophical question of what is law means. Like, what is it even asking? How would you go about answering it? And how would the answer help explain how we might use it to answer questions that lawyers and law professors care about? Okay, so let me start off by distinguishing between the question, what is, this is a classic philosophy thing, because I'm going to say something and it's just going to sound like the same thing, but it's actually different. So what's the difference between, there's a difference between what is law, and that's what philosophers are interested in, and then what is law? That is, what does the word law mean? Now, I'm not interested in what the word law means because, who cares what the word law means? I want to know what the law is. I want to know what is it about the thing that is referred to by that word. Besides, other countries, I know Americans find this hard to believe, but other countries have law too, and they have their own words for law. So why would you spend all your time trying to figure out an English word when there are lots of languages in the world and an infinite number of possible languages? Okay, so what we really are interested in is the nature of law. Okay, now what does that mean? So I say, okay, when I say what is law, I don't mean what is the meaning of the word. I mean, what is the nature of the institution that is referred to by that word? Now, what the heck does that mean? What does it mean to ask about the nature of something? Well, there are two basic possibilities, okay? One possibility is what we're asking about is the identity of law. That is, we want to know what makes law law and not something else. So, for example, you're the DSNLU is an L. That is, it's a law university, and the question is, in virtue of what makes it a law university? If you're going to tell me, well, they teach law, I'm going to say, well, what makes it the law that they're teaching? Well, it has law in the books that you have to buy. Well, what makes it the law in the books? So there's the first question is the identity of law. Like, what makes law law and not something else? So we have these questions in philosophy all the time. We want to know, what is knowledge? I mean, what makes knowledge knowledge and not something else? Here's the example that I always use is what makes 3 3? I mean, what makes 3 3 is it's the number after 2. Okay, so that's the identity of 3. So we want some. It's not going to be such an easy answer, but we want a similar answer about law. Okay, that's one meaning of the nature of law is the identity of law. The other possible meaning of the nature of law is what I call, we want to know what the implications of something being law are. That is, instead of wanting to know the identity of law, we want to know what follows from the fact that something is law. Okay, so let me use the number 3 as an example, and then I'll go to law, because I think this is the easiest way to see how the identity of something can be different from what necessarily follows from that identity. As philosophers would say, there's a difference between the essential properties of something and its necessary properties. Okay, so we said the essential properties of the number 3, what makes 3 3 is that it's the number that comes after 2. So, by the way, when people ask you, you watch this video on YouTube, what did you learn? You can say, I learned that 3 comes after 2. So don't say I didn't teach you anything. So, as part of the essential properties of the number 3, that it's the number that comes after 2. But there are many necessary properties of 3 that has nothing to do with the fact that it's the number that comes after 2. So, for example, number 3, the number 3 is a prime number. You know, that necessarily follows from the fact that 3 is 3, but it's not part of the identity of 3 that it's a prime number. Remember, I said that what makes 3 3 is that it's the thing that comes after 2. So, you know, if you're a mathematician and you do number theory, you don't stop just when you find out that 3 is the number that comes after 2. You want to find out all about 3. You want to know it's a prime number. You want to know all the crazy things that number theorists are interested in. So when you say, what's the nature of 3, you can mean what makes 3 3, the identity, the essence, or you can mean, given that something's 3, what's true of it? What's necessarily true of it? Okay, what follows from it? Okay, and I want to say the same thing happens in the case of law. When philosophers ask what is law, understood as what is the nature of law, they can either mean what makes law law and not something else, or they can mean, given that something is law, what follows from that? Okay, what is necessarily true of a legal institution by virtue of the fact that it's a legal institution? Okay, so we might mean one of two things, and in fact, we tend to mean both of them. Like this, the study of jurisprudence is the study of both of those aspects. Now, jurisprudence isn't just about the nature of law, and I can talk about that afterwards, but it is in some sense like, you know, one of the central questions in jurisprudence are these two questions about the identity of law and the implications. Okay, so now, how would we ever answer the question, what is the identity of law? Okay, now the way jurisprudence has worked in, at least in the Anglophone world, is through a process normally known as conceptual analysis. So let me briefly describe what conceptual analysis is. I'm sure people have heard about conceptual analysis before, but let me just describe one way of understanding what philosophers are doing when they're sitting in their armchairs thinking about what is the nature of something, okay? Well, one way to think about it is like, it's like detective work. Let's say someone's murdered and the police detective collects clues at the scene of the crime and uses techniques such as the, you know, process of elimination and uses various facts that they know about human psychology to figure out the identity of the killer. Okay, so something's happened, we want to know who did it. Now, I think the same kind of thing happens in conceptual analysis. The philosopher also collects clues and uses the processes of elimination and various forms of logic for a specific purpose, which is to elucidate the nature of the identity of the thing that falls under the concept in question. Okay, so instead of trying to figure out who the murderer is, we're trying to figure out what is the nature of the thing that falls under the concept we're analyzing. But the big difference, and this is what makes philosophy and not social science or criminology, is that the evidence that the philosopher collects is different than what the police detective collects. The police detective collects statements or collects observations about the true states of affairs, what's true. Now, what the philosopher does is doesn't just pick things that are true, but are truistic, by which I mean obviously true. So the clues for the police detective is, oh, here's a smattering of blood over here, which has certain DNA, which matches the suspect. For the philosopher, it's like, that's obviously true of law. Like, if you didn't know that law, let me give you an example of a truistic statement, that some laws impose obligations. Now, if you didn't know that law imposes obligations, then you wouldn't know what law was. So what we try to do in philosophy is we try to collect all the things that are so obviously true, you would never bother saying them. Then it's an interesting, weird thing about philosophy, which is what makes it so hard is that we're trying to figure out the things, we're trying to articulate those things that are so obvious that we would never articulate them, right? Things that are just, we say, in English, we say, hiding in plain sight. They're just obvious, so you just would never, ever say it. But the trick in philosophy is to come up with things that are just so obvious you would never think to say it, and then say, actually, here are a list of all the incredibly obvious things about law. Now, what must be true about law that not only makes those things true, but obviously true? Okay? The trick is to try to figure out what is the kind of thing that would not only make those statements true, but obviously true. So you say all legal systems impose obligations. You say, oh, okay, that's great. Well, what must law be like that is obviously true that it imposes an obligation? Like, what's just obviously true about it? And so that's one of the tricks in philosophy, is to figure out what's so obviously true you would never ever say it, and then try to figure out what must be true so that all those things are not just true, but obviously true. And that is super duper crazy hard. And, and I think it's really fun. It's really fun because, you could do it just sitting in a chair, and that's kind of fun. You don't have to wear a suit. Like, I'm wearing shorts right now. Like, you could just do it. I mean, it's like fun, just games in your head. But here's the great thing. Okay, if you do it well, okay, you will come up with a model, an idea, a theory, which explains the nature of law. What must be true about law in order for it to be law, and what necessarily follows from that. Now, let me explain. I just want to say in general, I'm going to try to argue why this is instrumentally valuable. But since you're students, I want to get across to you the idea that things don't have to be useful to be valuable. It can just be fun, okay? You can have fun learning about law and doing philosophy. That's enough justification, okay? It also is true that, like, if you want to obey the law or make an argument in front of the high court about the nature of the Constitution, it would really help if you knew about the nature of law, which is what I'm going to try to show you right now, okay? So let me, I'm going to, how much time do I have? How much time do I have? Do I have about 15 minutes?
You can take more than that, Professor Scott, not an issue.
Okay. 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 Let me. I think it'll be 15 minutes, but because I want to have a chance for questions and answers. Okay. Let me make an argument for why knowing about the nature of law is practically useful for lawyers. Okay. Let me begin by introducing the notion of a legal fact. Now, again, I told you that philosophy is all about saying the obvious thing. So, I mean, a legal fact is just a fact about the existence or content of a particular legal system. So it's a legal fact, for example, that Bulgaria has a legal system. It is a legal fact that the moon does not. It's also a legal fact that in Connecticut, the state that I'm in the United States, on the highway, you're not allowed to drive more than 65 miles per hour. I'm talking about really basic stuff, just a legal fact, okay? Now, here's a truism, okay, about law that you may never have articulated to yourself, but I think you would maybe agree with me that it's obviously true. Legal facts are not metaphysically basic. Now, what do I mean they're not metaphysically basic? What I mean is, if you were a scientist and you were making an inventory of everything in the universe, you would say, okay, there's an iPhone here, and there's a electrical field there, and there's a quark here, and there's a muon here, and there's gravitational field here. You'd say a lot of those things. Probably you might not say this is an iPhone. You might say this is a collection of silicone crystals, or I don't know what you would say. But I think it'd be obvious to us that we wouldn't say, that the scientists wouldn't say, oh, there's the law that you're not allowed to drive more than 65 miles per hour. It's just not basic. That is, the law is in Connecticut, you're not allowed to drive more than 65 miles per hour, but that's just like a feature of other facts that are more basic. Meaning people, there are agents, there are persons who have engaged in some kind of weird practice where they wear weird clothes and they go to these buildings and they use gavels and they say things like, hear ye, or oh yes, or all the kind of weird things that lawyers say. That wouldn't you would reduce the legal facts to some more metaphysically basic facts. Okay. Now, my question: what is the relationship between the legal fact and the more metaphysically basic fact? Okay. Now, it's one of what, as philosophers say grounding. That is, the more metaphysically basic facts make it the case that the law is true or not true. That is, the more metaphysically basic facts make it the case that that legal facts are the way that they are. Okay? Now, in philosophy, the basic controversy, there's no basic controversy. One of the basic controversies is, what are legal facts ultimately dependent on? One answer, which often goes by the name legal positivism, holds that legal facts are ultimately dependent on social facts alone. That is, they simply depend on the behavior, the attitudes, the actions, the intentions, the beliefs, the utterances of people acting together. Morality has nothing to do with it. The other view says, oh no, morality has everything to do with it. That is, it's not enough for legal facts to be determined by social facts. There are things in law that make it that legal facts have to depend on morality as well. For example, remember what I told you early on. I didn't tell you, I just reminded you, because hopefully they're truisms, you knew this already, which is that legal systems impose obligations. We said, yeah, of course, they impose obligations. Like when I was a kid in the United States, we would say, duh. You know, like when somebody said something incredibly obvious, you'd just say, duh. Well, that's right, duh. Legal systems impose obligations, but the natural lawyer, the anti-positivist, says, aha, if the law imposes obligations, then the law must depend on morality as well. Because as David Hume, the Scottish philosopher of the 18th century, famously argued, you can't derive an ought from an is. That is, you can't get obligations just out of social facts alone. You need something that has real oughtness. You have to make reference to things that are reasons for people. So if law imposes obligations, the legal facts must ultimately depend on something that can itself create obligations. And the only possible thing the natural lawyer can imagine is morality doing that, the natural law. So we have two camps here. We have a camp that says social facts ultimately depend, legal facts ultimately depend on social facts alone. I call those legal positivists. And the other says, I call these natural lawyers, that legal facts ultimately depend on social facts and moral facts as well. Okay, that's the divide. Now, why should you care? For the following reason. Notice that the relationship between the legal facts up here and the metaphysically more basic facts here, that's a necessary truth. That's necessarily true of law. Whatever it is, if legal facts ultimately depend on social facts, well, that'll be a necessary truth of law. But if legal facts are dependent on social facts and moral facts as well, that'll also be necessarily true of law. Now, if the positivist is right, the answer to so many legal questions are gonna be, what are the social facts? If you wanna know how you should interpret a statute, if the positivist is right, you're gonna have to know something necessarily true of law, namely, whether legal facts, which is what you want to know, whether they depend on social facts as well, only, or moral facts as well. If you're a positivist, you're not going to engage in moral reasoning to know what the law is. Because we just said that the law doesn't depend on morality. So we're not going to make reference to morality in arguing what the law is. It won't be an acceptable argument to say, if we interpret the text in this way, the community will be better off or rights will be better protected. If you want to know what the law is, and the law ultimately depends on social facts alone, you cannot engage in moral reasoning. But if you're a natural lawyer and you believe that legal facts ultimately depend on moral facts as well, then there's no way to answer these questions without engaging in moral and political philosophy. You will have to make arguments about justice, about fairness, about the relationships of rights to the general welfare, what the claims of the individual has against the community, and what claims the community has against the individual. There will be no way to avoid it because it will be a necessary feature of law that what the law is ultimately depends on morality as well. And so it seems to me that you won't be able to make headway on figuring out what the law is in many of these cases without knowing what law is. Because knowing what law is means knowing A, what makes law the thing that it is and not something else, and what necessarily follows from that fact. One of the things that necessarily follows from that fact is what facts, legal facts, ultimately depend on. The question will be, do they depend on morality or not? And depending on how you answer that question, you will interpret legal texts differently. And that will tell you what the law is in a particular case. So when I'm trying to explain or trying to do the best I can in proposing, suggesting, is that what philosophers do is vitally important to what lawyers do, and that as law students, you should pay attention to jurisprudence not only because you want to get a good grade in the class, but you would like to get maybe good grades in other classes too, or maybe just because it's fun. In any way, I'm gonna halt right now and see if anybody's still listening, and you can ask me what you want.
Professor Scott, there are a few questions in the meanwhile, starting from what is law. So I'll just read out a few questions for you. The first question is, will COVID-19 change the concept of law?
So I have at Yale Law School, we have a little group of which I'm a member where we talk about the question as to whether COVID-19, how is it affecting the world order. I don't think that it will change the concept of law. I do think that there will be major changes in the way the international legal order operates. My colleague and I own a Hathaway. We wrote an article, a piece in Foreign Policy, which is available online, and I can retweet it from my Twitter feed. And that asked how the international order will change in light of COVID, given the fact that the United States has decided to retreat from the world stage. And so what Ona and I argue is that we hypothesize that what will happen is, instead of having hegemonic international institutions created and supported by hegemonic powers like the United States, like China. What we may see is what we call global clubs. That is where like-minded states join together to solve regional problems in ways like clubs solve problems. And so we talked about, for example, it's very possible that we'll see the way vaccines and pandemic and how countries respond to pandemics will very much be affected, I think, by the withdrawal of the United States from global leadership, at least has in the last 4 years. One other thing I would mention is the way in which surveillance will affect our views about security versus privacy going forward, whether we will consider it acceptable to have tech companies or the state tracking our movements in the name of the general welfare through contact tracing apps, through various forms of state or private surveillance.
Thank you. The next question is, good lawyer is one who knows where the law is, read the statute to find the law, and then interpret the same purposively to get into what the law ought to be. So is he the good lawyer? That's the question.
Okay, you know what I always tell my students? I tell them that the difference between a bad lawyer and a good lawyer is a bad lawyer thinks they're a good lawyer, and the good lawyer is not sure. That's a joke. But I mean, actually, it's a joke, but it's not a joke. To all you students out there, this is my message to you. Always think that you sound stupid. Seriously. I know I'm violating this constantly by talking what I'm doing, but I'm always thinking, am I making an idiot out of myself? I have often spent 10 years writing a paper. I think the difference between a good lawyer and a bad lawyer really is the good lawyer is constantly afraid that they're making a mistake. And that's the precise thing that stops them from making a mistake. Whereas the bad lawyer thinks they got it all covered. I always think to myself, how can this be misconstrued? How can this, how am I messing up? If you worry about that constantly, I can guarantee you two things. One is you will rarely make a terrible mistake. Number two, you will be miserable. Still, you can't get one without the other. I'm sorry. Anyway, what I would say to the questioner who said that about a good lawyer should interpret the text purposively, read the text and read it purposively, I would say ask that that questioner, why do they think that? That is, there are lots of people who think that's not true. There are lots of people, they're called textualists or strict constructionists. I mean, there are lots of interpretive methodologies according to which they think that that's a terrible way to proceed. And I will tell you why I think it's so I'll just give you an inkling as to what I would say if I were talking with this person in a back and forth. I would say, on the one hand, what law is trying to do something. And so it makes sense to, in some sense, interpret the law purposively. However, there's another thing that law is interested in doing. It's not just merely interested in advancing some social aim, but it wants to do it in a context where the people that it tells to do things It wants to know whether they can trust them. That is, one way of thinking about law is that it's not just a distribution of power and authority, but a distribution of trust and distrust. And the extent to which the lawyer is arguing in a forum where the legal system does not trust the interpreter, purposive interpretation would be inconsistent with the levels of distrust presupposed by the law. It would only make sense to engage in that kind of interpretive process if you were arguing in front of an interpreter who is highly trusted and was given a lot of discretion. But if not, you should do the opposite. You should read the text really according to its literal meaning. So, for example, my own view is that in international law is an area of perhaps the greatest distrust of any kind of human legal system, because you're dealing with rivals who have existential power over you or threaten to have existential power over you. So therefore, we have to assume that they're going to act in their own best interest and maybe not with the greatest degree of character. And so therefore, when we're interpreting, let's say, the UN Charter, we should interpret the rules about war in a very strict way, not allowing lots of cases like humanitarian intervention to go forward unless there's Security Council authorization. The point being that whether you interpret a text strictly or loosely or purposively, I think really depends on the nature of trust in the legal system and the venue in question. And I think that's because of what law is, which I think is a planning system. I talk about this in my book, Legality, and I have some podcasts on episodes on my podcast where I talk about the relationship between the planning nature of law and interpretation. But suffice it to say that, this is part of the conversation you would have if somebody says a good lawyer interprets things purposively. I'd say, well, why do you say that? And we would get into what I hopefully would be a jurisprudential conversation.
Sir, before I take the next question, our Vice Chancellor, sir, has a question. Sir.
Okay. Well, thank you, Kiran. So, Professor Scott, this is not a question. I would like to know your impressions about, in the beginning you spoke about the law and is law. Okay. Because in the democratic nations, every generation has their own right to make their own law. So do you think that the law is evolved in any society, and except the Muslim countries where law is static, which is not changeable because the law flows from Quran? But whereas in the democratic countries like UK, USA, India, do you think that there is the law evolved at any point of time? And in the light of each law and the law, which you have discussed, how do you look at a theory of justice by John Rawls and the idea of justice by Amartya Sen? So how do you distinguish between these two writers? One has used in terms a theory of justice. Amartya Sen, he said that the idea of justice. So is it the only idea? Just how throw some light on these two issues.
And so I'm sorry. Thing kept on going in and out, so I didn't hear the question very clearly. I'm so sorry. Can you, could you maybe?
Not word to word, I'll try to repeat it. The question
Please.
is, speaking about law, it is on social facts and psychological facts. Now, if at all every generation, tries to define what is the law, in a democratic system, does it change? For example, when we have a static system where the law is drawn from a book, for example, in Muslim jurisdictions, the Sharia law is drawn from Quran. Now, in democratic countries like UK, US, India, law is in one sense dynamic. So, is it different? No, does every generation get such right? If so, is it something like Vice Chancellor sir was trying to make a distinction between John Rawls' justice, I mean theory of justice, and Amartya Sen's the idea of justice. So, is it only one idea of justice, or is it way beyond that?
The idea of justice,
Yes, sir.
not your idea. It is the
Yes, sir.
idea of justice.
Okay.
Okay.
Professor
I'm
Scott,
sorry. Rawls versus who's the other person?
Amartya Sen, the idea of justice.
The idea of yeah. Let me so this is actually the one. So I did spend actually some of my Islamic jurisprudence books are in the background. I did spend a fair amount of time on Islamic jurisprudence, just to I'm not an expert by any means, but just as an interested consumer. And one of the interesting things, of course, is that Islamic, virtually all of Islamic jurisprudence, is a very dynamic system. There is a kind of radical Islamist, Wahhabist view according to which the law can't change. And in fact, it would be considered a form of divine usurpation for man to think that they can create law. But even one of the things that scholars who've studied, like even kind of ISIS communities in Syria have shown. A student of mine, Mara Revkin, showed is that of course even in a very strict system like a kind of Wahhabist radical Islamist idea, a Qutbist idea. Of course, legal officials are creating law and new institutions and adapting the law for new purposes. This is the way in which a legal philosopher would approach any claim that said, "Oh, the law is completely static." I think the legal philosopher would say there can't be a legal system that's completely static, because one of the things that law does is it precisely is an institution that allows the community to adapt to changing circumstances quickly. So what then becomes fascinating is the way in which a particular jurisprudence, a particular kind of Islamic jurisprudence, will reinterpret so much of legislation as a form of interpretation. I think the same thing happens in civil law countries. But there, the notion that they're engaged in interpretation is completely covered over. They act like they're not, of course, in French, the French law says courts are not allowed to interpret the law. So there's all these tricks that legal systems engage in to try to pretend as though they're not making the rules, but they are. And that's part of what's fun about jurisprudence. This is another way in which jurisprudence, I think, is really fun, is the fact that you get to see a legal system make a claim that can't be true, and then you think, oh no, what they mean is this and this, and you kind of come up with some view about what is happening in that legal system. So that's what I would say. I would kind of push back at the idea that there are some dynamic legal systems, and they're the ones in the West, and the kind of, I don't want to say Orientalist, but a kind of non-Western legal systems that are static. I don't think that that's in fact true, but I'm so not an expert in it. I'm just a dabbler.
Okay, sir. There are one or two questions on normative jurisprudence. So I'll just take those two questions together. Maybe you can answer it. Now, the first one is, how does analytical jurisprudence link with normative jurisprudence? Add to it the fact that, the next question is, would it be correct to define law as that which connects factual premises to normative propositions?
I'm sorry. I'm trying to process that. Could you try again? Yeah. So, what is the relationship between analytic and normative jurisprudence?
Now, would it be correct to define law as that which connects factual premises to normative propositions?
Oh, that which goes from factual propositions to normative propositions? Is that
legal reasoning, factual premises to normative propositions?
Well, that is the way in which it's presented, but we know that can't be true. So again, I feel like people are setting me up here. They're like, you're like handing me these beautiful questions to make me look smarter than I am. By the way, I don't think I'm looking smart. I'm just saying I'm looking smarter than I would be otherwise look had I not gotten such questions. But the point is that how can normative propositions follow from factual premises? That's what David Hume tried to argue could never be true. You can't get an ought from an is. So how can that statement of law be true? Now, what's really fascinating is that the questioner is right, in the sense is it does seem as though the law is deriving normative consequences from factual premises, and then the question becomes, how does that happen? So this is one of the things that I said about philosophy, is that you try to figure out what is so obviously true that you would never say it. But there's another part of philosophy that's like, if you actually thought about it, you'd realize that what you're saying makes no sense at all. And so
I get it.
Yeah, right. And so then the thing is like, well, that makes no sense at all. Like, why are we doing what we're doing? Why are we saying what we say? And then that becomes a puzzle. And so that's it's kind of fun too. I have to say, one of the greatest moments when you do philosophy is when all of a sudden you become terribly confused. Like, like you think you understand what you're talking about, then all of a sudden you have no idea what you're talking about. You're like, what have I been writing about for the last 3 years? What did I get a PhD in? I don't understand anything. And this is the moment that you live for, because it's at that moment that you're about to crack some major puzzle and discover something very deep and profound that you didn't realize before. Those are very few and far between, but when they happen, they're really wonderful.
Maybe this question will contextualize the whole discussion that we had in the past 20 seconds. Won't adding philosophy make law more of a prejudice to certain norms?
I'm sorry. Please say that again, please.
I'll repeat it again. does adding philosophy make law more of a prejudice to certain norms? I mean, we are going back to inductive and deductive.
I see. Well, yes, I would say, because, well, let's put it this way. Let's say you were a natural lawyer. Let's say you thought that law ultimately depended on moral facts as well. At that point, you wouldn't just kind of accidentally make moral arguments in legal briefs. You'd make it directly. You'd say, this is why these norms require that we say that the law is thus and so. So I think it matters if you're a natural lawyer. I want to say it also matters if you're a legal positivist in the following sense. One of the big arguments to why people said that they were positivists historically, and one reason which I find very appealing, is the idea that, there can be law and it can be awful law, that it can be subject to criticism. One of the things that the legal positivist says is that unjust laws are still laws, and therefore you should fight them. So by saying morality doesn't determine the content of law is not a way of saying morality doesn't matter to law. Of course, morality matters to law. It just doesn't matter in terms of telling you what law is, but it does tell you when you should change the law. And so one of the things that positivists have wanted to do is they've wanted to take away all the kind of moral normativity from legal reasoning so we can see how awful law is, not sugarcoat it, not kind of tweak it so that it's better than we think it is, or to say, oh, it's so evil that it's not even law. Because how do you change something that's not even there? So what the positivists has wanted to do is kind of like stare law straight in the eye, saying the law is thus and so, and you're bad, and we need to change it. So I also think that there's a way in which philosophy, even if you're a positivist, is a way helps brings norms, help brings. I'm sorry.
We get it, sir. We get it. You can take
I need some code patching. I don't know why I was unable to articulate that last sentence.
Can I take the next question? This again connects us back to the deep of the philosophy. Isn't legal fact similar to a mathematical constant, a fiction, and in that sense, a metaphysical entity?
Yeah, good question. Great question. Right. So, so I think that law, the concept of law, is an abstract object. So I'm going to say one thing. So there are lots of things to disentangle here. So the first thing is that a legal fact is not a legal fact is a fact about an abstract state of affairs. That is correct. No. Actually, I'm not quite sure. So, no. If you think that law is ultimately constituted by social facts, then legal facts are themselves not abstract. Okay, so I'm sorry. So I was just saying, it took me a while to think through. So a legal fact, insofar as it depends on social facts alone, then the fact itself would not be abstract. It would be concrete. It would be as concrete as social facts were. Now, that a legal fact depends on social facts, that fact is an abstract fact. And that is like mathematics. Now, some people will want to say, "Oh, I don't want to accept what we call in philosophy abstracta, that is, abstract objects into our ontology, because it seems so weird." And my response to that is always, well, you're perfectly happy thinking about the number 5 or the number 3, our friend, the number 3. And now, if somebody were to push back and say, well, the number 3 doesn't exist either, it's just a way of speaking, then I would say, okay, then the abstract legal facts that we were talking about, those are also a way of speaking. If you're unhappy with the number 3, then, you know, nothing depends on it, I would say. But I think lots of us think 3 exists. There's a question is, what do we mean that 3 exists? But, you know, I've doubted many things in 2020. That's one thing I haven't.
That's a wonderful way to end the question. Now, 3 more questions which I'll be taking. I mean, there's a continuous stream of questions coming on YouTube, and I get personal messages on YouTube. So I zeroed down to 3 more questions, sir. We'll try to finish it as quickly as possible.
Okay.
Now, the first question I'll take now here is, considering the positivism and keeping naturalism dormant, would it be correct not to typecast or categorize what is law and only consume it while considering what is the law?
Oh, why don't we just skip the philosophical question and go directly to the law question? Is that the question? No, I'm sorry. I'm, you know, I'm just, you know, I'm slow today.
Not an issue, sir. Not an issue. You want me to repeat it again?
Please. I'm so sorry to everyone.
Considering the positivism, keeping the positivism in perspective, and, you know, for the time being, ignoring naturalism or the natural school, would it be correct to not typecast or categorize what is law and only consume it while considering what is the law?
Oh, so if you were a positivist, would you only consider the question, what is the law, without worrying about what is law?
Yes.
Is that?
Should we?
No,
for the time being is the question.
Okay. Well, no, I mean, I think you would, I think you would, you wouldn't know that you were a positivist unless you asked the question, what is law? Now, there is a sense in which once you're a positivist, you don't have to go back and, you know, reread the concept of law and theory of justice and all that. You don't have to read all of philosophy in order to make an argument. And if you're a positivist, it's not going to. So any kind of positivism that makes any sense is not going to be a positivism that says, yeah, just read what it says in a book. That's the social fact that answers the question. If you're a positivist, it's going to be some complicated story according to which certain kinds of social facts matter. And based on that, what should you do? Let me give you an example, okay? So according to, I think that laws are plans. I think when the law tells us what to do, it's in part planning our lives. You know, I plan my kids' lives, the dean partially plans my life and the faculty's life. So the law partially plans our lives. And I think that laws are plans. And I think that the proper way to interpret the law is proper way to interpret plans. We do it all the time. We do it like hundreds of times a day. So it's like, I plan after I get off this call, I plan to go get lunch. So like when I shut the thing off, I'm going to then follow my intention to get lunch. And I'll try to think, when I said I was going to get lunch, what did I mean? It probably meant I was going to go get lunch, around the time I normally get lunch. So, it's like, it's just plan-based reasoning. And I think essential to plan-based reasoning are questions of trust, which is what I mentioned before, and questions about what the purpose of the plan is. So that's why I think that interpretation is often a kind of push-pull between purpose of interpretation held back by whatever trust relations make that kind of discretion dangerous. And that itself is like, that's not like a matter of looking in a book. That's a form of reasoning, which, it's not rocket science, but it's not, just Googling it.
This is another interesting question. Do you believe there exists free will, or is it illusionary? And what are its implications on law and morality?
Wow, this is really the question always when you say, do we have free will, is like, what do you mean by free will? I mean, so there's gonna, the standard debate is gonna be between people who think we don't have free will and people who think, between people who think we don't have free will because we live in a deterministic universe and we ourselves are made out of matter and matter is subject to physics. So there are people who are going to think that we live in a deterministic world and therefore we don't have free will. And then there are other people who are going to say, no, we do live in a deterministic world, but it's possible to talk about free will even if every event has a cause. That view is called compatibilism. And just like what is law will affect what you think the right way to interpret legal systems are, I think how you come out on the free will debate, what kind of compatibilism you adopt. If you adopt it, you could be a libertarian and think that free will is possible, even if determinism isn't possible, or even if it is possible. And that's going to affect how you think of the criminal law. And my colleague, Gideon Yaffe, has done brilliant work, I think, trying to show how compatibilist views on free will affect how we should interpret the criminal law. So that's another way in which philosophical jurisprudential questions connect up with questions about what is the law.
To top the whole discussion with the last question, there's this a very different question which will serve the purpose of the lecture, is what I think. This question says, if I'm the sovereign or the legislature of a democracy, let's say India, how does the different theories of jurisprudence impact me or help me in formulating the statutes?
Yes, so I would suggest that, with all due respect, read maybe my book, which will show that on the one hand, but also interpret what will matter is the nature of the Indian Constitution. Like I just read this. Like I said, I'm not a specialist in Indian law by any means. I mean, but I read this wonderful book by Madhav Kozlow, India's founding moment, which is a very sophisticated and interesting way of understanding the particular ideological underpinnings of the Indian Constitution, which make it makes it somewhat distinct from other kinds of constitutions. And what would be, I think, fascinating is to see how such kinds of interpretations of India's constitution, given a proper theory of the connection between the nature of law and interpretive methodology, if you put the two together, what would you get? And I did some of that in my book about the American Constitution, but it seems to me this would be a really fascinating thing to do for the Indian Constitution, given the fact that, as far as I understand it, there's been a lot more interest in India's founding moment, constitutional moment, and lots of interest, of course, about the High Court and the relationship between that and constitutional interpretation in this very, let's just say, exciting moment in India's.
Give replies to all the interested people. It's not a compulsion. It's just an academic.
I was like, I didn't know this talk had homework.
Definitely not homework, sir. This is what we get. For example, you are referring to one or two books, so it will be very helpful for us if we get to know the names of the books. So if we can document it, we'll send it to all the registered participants.
Or another possibility is I can post some answers on my Twitter feed.
That is wonderful. It is accessible. Yeah. All the people who are willing to. I mean, that serves the purpose more than that. Not the one who had asked, not just the ones who had participated. It's for the whole world. So we'll be very happy to have it. So we'll try to send the questions, sir.
Okay, yeah. So it's at Scott J. Shapiro, where I say
what we'll do is, maybe after the end of this video, maybe once we try to filter every other thing out, we'll also send a link of your podcast and also your Twitter handle to all the participants.
That'd be terrific. Thank you so much.
Okay, sir. Manashwi, it's for you to take over.
Yes, sir. Thank you so much for the insightful session, sir. I would request our registrar, sir, Professor C.M. Rao, to take over for the vote of thanks.
Good evening, everyone. On behalf of the DSNLU University, I thank Professor Scott Shapiro for his valuable time sparing for us and delivering the lecture on what is law. I thank our Vice Chancellor for supporting us for arranging this lecture. I also thank Professor Dayanandamurthy for opening remarks. Further, I thank Mr. Boyala Kiran for arranging a wonderful feast at the evening of Friday. And at the same time, I thank Manaswi and also Kathy Ananya for doing the rest of the things, for completing this particular lecture, a wonderful aspect in the history of DSNLU family. Thank you, one and all. I also thank all the participants who participated in this particular thing and who posed questions, because the paucity of time, we may not get the things done. And in the meanwhile, Mr. Bhairavan will take care of your answers. Thank you, one and all, for a wonderful presentation and also participation. Thank you, one and all.
Thank you.
Thank you, sir. Daniel, sir, you have something to say? VC sir, I think VC sir is online, sir.
Yeah. Just to say thank you to Professor Scott and thank you, Kiran, for arranging a wonderful lecture. Thank you.
Thank you.
And so you're saying something.
So much, sir. Thank you. Nothing. Thank you so much, sir.
Thank you so much.
Professor Scott, just be online for a moment. Just be online. Maybe from the bottom of my heart, I thank you for sparing all the time that you had. It was supposed to be, I mean, you said you'll speak for 30 minutes, but somehow we had extracted almost more than an hour and a half from you. Thank you so much for what you did.